order has been passed by the recovery officer. It is on basis of a certificate order passed on 16/8/21. Where is that order?
That has also not been given to us.
So you make it. This is not the court who will supply you that order.
I understand, Lordship.
It is very easy to say, I have not received anything. Come to the court. You get everything.
Lordship, the agreement with my bank accounts have been frozen.
Show that where you have said that you never received this order.
Lordship, my bank accounts are frozen. Even my personal bank accounts are frozen, and my another firm which I am running partnership for.
It is up to you as a lawyer where you take your client. You make him run from here to there. His bank account will remain frozen. You don't go to the correct court.
Lordship, in the instant case, while order dated 18 January 2023, notices were issued to the respondents.
Yes?
Lordship, in the instant case, the petitioners agreed by annexure 2. By
18 January, what do you want to say?
Lordship, notices were issued to the respondents.
Then?
Thereafter, no reply has been filed to date. The grievance of the respondent, the petitioner is that he has been directed to pay a certain amount, which is annexure 2, at page 35, 5,74,813 towards ESI. But before passing such order, a recovery order, no show cause was issued to me. We had received no certificate. Our bank account were directly frozen. We went to the bank, then they told us that they had received an order.
Where is that order?
Page number 35, annexure 2. Even this order was not received by us because the address, our address is mentioned wrongly. That's not our address.
This order has been passed by the recovery officer.
Lordship.
It is on basis of a certificate order passed on 16/8/21. Where is that order?
That has also not been given to us.
So you make it. This is not the court who will supply you that order.
I understand, Lordship.
It is very easy to say, I have not received anything. Come to the court. You get everything.
Lordship, the agreement with my bank accounts have been frozen.
Show that where you have said that you never received this order.
Yes, Lordship. I have mentioned it.
Not in your petition. File representation anywhere.
Lordship, I have mentioned in my petition at paragraph number 12.
Because that order is appealable.
That I understand is appealable, but if this section provides, section 45 provides that they have to give us an opportunity to be heard. No show cause has been given to me.
So that is not an argument to be taken in appeal.
Lordship, but the Supreme Court is the judgment of Whirlpool Corporation versus
Which is not required to be shown to that particular appellate authority.
Lordship, all I am saying is that an opportunity may be given to me to be heard. Let them issue me a fresh show cause. I will establish the fact that ESI is not even applicable.
Alright, we admit, let them file their reply.
Lordship, my bank accounts are frozen. Even my personal bank accounts are frozen, and my another firm which I am running partnership for.
It is up to you as a lawyer where you take your client. You make him run from here to there. His bank account will remain frozen. You don't go to the correct court. Keep on. This court is not going to pass an order without giving them an opportunity of filing a reply. They have not filed their reply.
Let them file the reply.
So we will admit it. What more can we do?
Let them file the reply. It may come up after 1 week.
After admission, they will file their reply. That is the procedure in this High Court.
If it is admitted, it will come up.
Then you knew about all this, and you have not gone and you have not challenged that order of 16/8/21. This is a consequential order which you have challenged, and you are talking about that order. That order, before that order was passed, you were not given an opportunity of hearing. Where will we come to know when you have not placed that order on record?
They may file a reply, they will take it on record, but admitting the case.
You start sending a postcard to this court, and we will ask them to file reply. That would be better.
I'm not arguing on that.
Mr. Counsel, you have at least some standing in the High Court. You know what is the manner in which writ petitions are filed, are required to be filed. You have to do some exercise before coming to the court.
Only because there was no.
So if the client comes to you, says that, look sir, I have this order, and you say, all right, file the petition. You will have to search out, you will have to get the other orders. You have to get it under RTI, if that is not available to you. Why is that act has come into force? How can, you know it very well this court is going to throw away this case without that order being on record? Or is it that we will not? We will presume something has happened. The courts usually take your word. That is how the notices were issued. But when one goes back into your file, you find that document is not there.
Only because there was no notice issued, that's why the previous bench had issued notice.
The petitioner has filed this writ petition challenging the order dated 23/9/21. On perusal of the order dated 23/9/21, this court finds that the order passed by the recovery officer is based on a certificate dated 16/8/21 issued by the authorized officer ESI Corporation for recovery of amount of 5,74,813. The order dated 16/8/21 has not been challenged by the petitioner in the writ petition. In view of the petitioner having not challenged the original order, the consequential order cannot be examined. Writ petition is accordingly dismissed.
Liberty may be given to oppose that later. Humble saying. That liberty may be given because if there is a dismissal order, they will take
Item
it up.
5, Mr. Avanish Kumar.
Next case.